Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay, good morning, everybody. Hello, Tammy. Hello, Darkside. Hello, Maestro. Thank you for moderating. Hi, Iowa. Let me reflect. Doesn't look like we have intelligent life in the courtroom yet. So I assume that we're going to hear about chalks, meaning presentations for the jury. Hear about what quotes maybe we're going to see in opening statements from Karen Reed, possibly. Just never know. Maybe we'll hear from this guy.
must leave.
Okay, we have a fan. Your latex spouse says, anyone else embarrassed over Carl Steinbeck losing his mind over trying to prove Karen Reed's innocence? He sounds, last time I tuned in, he was talking about Commonwealth being Nazis, which I found extremely offensive, as any Jewish person would. He doesn't know what he's talking about. He's just up there posturing and trying to appeal to the free Karen readers. Or he's always been this. I mean, we've always seen hints of his paranoia and delusions, but he's clearly out of his mind. I don't know if he even believes what he's saying, if he's just desperate for money. I have no idea. I don't know him well enough to know. Exactly. He's German. He's German. He's talking about Nazis. I was like, well, these are pretty kind Nazis. These are Nazis letting Karen Reed get her jeans. If he's talking about the police. Hold on. I got to deal with my cat. Hold on 1 second. Right. So I used to think it was about his wife or his new wife, his new bride. So he started this before he really knew anything about it. But what kind of personality doesn't check out a case before you throw your weight behind a cop killer? I mean, any of these campaigns, you have to think that there might be a chance you're wrong, unless you're so narcissistic, and he might be, that you think that any way you go, there's no chance you could be wrong. So what is he doing? It's embarrassing. And next time he says justice for Dan Markel, I'm just going to vomit, because I know how hollow it is. Because apparently no justice for the O'Keefe family. He cares little about justice for the O'Keefe family. But Dan Markel, it's hugely important that all the killers be caught, but not here. Yeah, I unsubscribed from him too a long time ago. Just another legal grifter on the internet. We have so many of them. I really don't like any of these law tubers. There's not one that I like. If they were good lawyers, they wouldn't have to be on YouTube. They make so much more money. I mean, I think people think that I think people think that there's like some huge profit in these videos when you get pretty decent views, but it's really pretty low compared to what it would be akin to maybe on your best, at least on my best video would be akin to a half an hour for a lawyer of work. So good lawyer. Yeah, they're all out of work. Why are they? Any good lawyer with what they can get paid with their law degree would gladly rather work as a lawyer. I mean, it's so much better paid. Anyway, you caught me on a very candid moment. I'm feeling very candid. I'm over all of this true crime nonsense. I've been at it too long. There's too many dark personalities involved in this. I mean, I know the community seems to love it. You know, the next lawyer that pops up. I mean, look at Nick Rakita. That guy abused his kids, drove drunk with them, starved them. And he was like the biggest law tuber. I always thought there was something wrong with him, but I mean, he was like such a force. How do you even supporting one defendant after the next? Yeah. And everybody, and then when he gets arrested, there's all these law tubers sweeping for him, saying, "Oh no, it was the state of Minnesota that was in the wrong. Give me a break." The guy got caught red-handed with drugs. Like drugs, his house is filthy. His kids are starving, wearing the same clothes day after day. And he was like, "You'll see, I'm going to fight this." And then he pled guilty. Oh, and he's living with another woman too, saying he's Christian. He's like living in this threesome situation. So it just seems like the better manipulator you are, the more manipulative you are, and the more cunning, the better you'll do on YouTube. And the more honest you are, the less money you're going to have coming in. Honesty is a handicap on YouTube. It's been my experience. So is Alessi going to bore us all to death? Let's see where we are with that might. He's saving it for trial. Yes, he's saving it for trial, 8%. Yes, he's going to put everyone to sleep with his boring talking points. This is like a lawyer like I've never seen. Have I ever seen a lawyer like this that just talks and talks endlessly to talk, that you just hoping that they bring it to a close? I feel like I've seen this before, and I'm trying to think. I really think it's his superpower. I think the judges just are like, "Okay, I'll give you whatever I want. Just please stop talking." It's like being held hostage. So awful. What a horrible, horrible human being. Can you imagine out of boredom and you want to get notoriety for your law firm that you join and throw your hat in the ring in a high profile trial and work for free just because you want more clients? You want a name for yourself, so you'll attach it to a cop killer? I mean, how disgusting, how morally revolting. Hey, Jenny Benny, thanks for the super sticker. I appreciate it. Yeah, he loves to listen to himself, and he makes no points. He talks endlessly without ever making a valid point. Talks nonsense. Debbie's asking, has there ever been a defendant who hires a jury member from the first trial? Not that I've seen, but Victoria George wasn't a deliberating juror. She was an alternate, but I haven't seen either. I've never seen it happen before. I'm curious if anyone else has. I mean, that was really, like Karen says, like she's just throwing everything at the wall to see if something will be helpful to her. And that's what they do with these innocence fraud campaigns. They'll take people from the street. We saw microdots Richie Keough in the ID Discovery TV show, in the War Room. I mean, these are essentially people just walked in off of the street. It's really show you the power of evil. It's really like the Omen or something. Damien and all his helpers. Does anybody remember the Omen? The nanny and the dogs. That's what we've got with Karen Reed. The nanny, the dogs, all willing to help Karen do her bidding and try to help her escape responsibility for her murder of John O'Keefe. Yeah. Then there's like disturbing people like Courtney Frost in our chat. You can't wait to see a cop killer walk free. Can't wait. Maybe she'll go out and kill someone in your family, Courtney, next. Run them over. Won't that be exciting? We'll send when Karen gets out, we'll send her to live with you, Courtney.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact-focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing, she's the anti-fraud light. Hard task warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy. Exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing, she's the anti-fraud light.
So if you don't know, we have a jury, 18 members now. So it's all happening. It's all happening. Okay, I have let my cat in and out of the room no less than 4 times since I've been on air. So I brought him up. Do you have anything to say? You have anything to say, dude? Now he's got nothing to say after meowing at the door for hours. In and out. The minute I let him out, he wants to come back in. Does anyone have a cat like this? I can't leave the door open because my boyfriend's working in the other room, so it would be very loud. Always the wrong side of the door, right, Susan Hicks? I know. This cat is, your cat does that constantly. I want to get a cat door, but it's going to be very expensive. And who knows if he'd even use it. Oh, by the way, speaking of animals, there has been an update on Valerie the dachshund. So this dachshund escaped on Kangaroo Island in Australia. It went under a car and then it ran into the bush. Like Kangaroo Island has snakes and spiders, and this little mini dachshund is living like a survivalist and doing really well. Over 500 days in Kangaroo Island. But they think that they're close to trapping her. She's walked into the trap area. So she may be coming home. Sadly, I feel, I don't know. I don't know if she wants to be rescued with these with these owners. These owners are like, this dog loves pink. She's such a princess. And I was like, clearly you don't really know your dog. Because this dog won't get anywhere near people. It's just like, this all are like running out in the field, their ears like flapping, looking so happy. So she's been spotted. So she went in and ate some of the food, and next time they're gonna close the door on her. Free Valerie, the miniature dogs. Let me see if I can show you since we're waiting. Here. There she is with another food bag. I'm obsessed with the story. And this is the trap area. And they've been trying to, but she's like super healthy. She's been out there for, I think this is 2023 when this happened. 530 days, something like that. That's the trap area. So they're going to close the door next time. They put her favorite toys and smell of home. The owners are like, she misses us so much. I'm not sure if that's true. She looks like she's living her best life. Here. This is a good one. Hold on.
Right around the world, and tonight we could be a step closer to seeing Valerie, the missing sausage dog, reunited with her owners. Volunteer rescue teams searching for the dachshund on Kangaroo Island has released video of what they say is Valerie walking inside their carefully prepared trap.
After 519 days, finally, a major breakthrough.
Just being like Val that we always knew. She just always loving the attention, loving her little toys.
Cardella Wildlife Rescue Group says this is Valerie inside their trap in the early hours of this morning. The cage is being filled with some of her owner's clothing and toys from home.
Some of them she had when she was a puppy, and to see her with them kind of out there, Yeah, it really tugs on the heartstrings, that's for sure.
Josh and Georgia first lost Valerie in November 2023 while on holiday on Kangaroo Island, and they're adamant it's her.
I was sitting there in bed one night, just going through old photos and comparing all her little marks and everything, and being like, it's 100% her.
Despite feeling comfortable in her trap, she's yet to be caught, a remote trigger for the door to be installed this week. The search for Valerie has captured hearts across the globe. Her story has been featured in some of the world's biggest newspapers, and social media users have been commenting from New Zealand, Netherlands and the United States. The search team is hopeful the attention will help.
The more resources they can get hold of, hopefully the more donations they can get to put towards the work that they're doing.
The prospects of a reunion perhaps growing by the day.
Imagine
the story she could tell. It would be insane.
Josephine Shannon, 9 News.
Okay. That's the dog we know. She loves her little toys, but she also loves, like, being a survivalist. One of the roughest islands in the world. Snakes and spiders. Deadly snakes and spiders. She's like, deadly snakes and spiders. No match for that little dog. Anyway, I've been just having fun following that story. That dog, Cindy, that dog is doing, I don't know, it's doing super well. Super well. They're bred for that. They're bred for hunting small rodents, dachshunds. You won't dress her in pink? Don't they look? I don't know. I wouldn't want to spend any time with those two. Like I said, I'm feeling very candid this morning. Like, run, Valerie, run. She's such a princess. She loves wearing pink. She loves her little toys. I think she's coming in for the food, guys. Is Carl taking super chats now? He used to not take super chats, but all his videos were monetized. So I don't know if it's just for the views. Is that who we're talking about? He used to be like, I won't take super chats. I'll donate it to charity. How are you going to work that out? So if you don't know, I guess you could go to the area where you can figure it out, how many super chats. But I think it's really just the views, and he wants to be important. He's an out-of-work lawyer.
Carl Steinbeck here. Want to talk about the Karen Reed case again tonight, and what I want to talk about is the 911 call that Jen McCabe made early morning hours.
Yeah, she made it because Karen Reed made her make it, as she does everything by proxy. What does he think? What does he think? He doesn't think it's odd that Karen Reed never made any of these phone calls, asked the niece to make the phone calls, asked Jen McCabe to Google how long to die in the cold, asked Jen McCabe to call 911, that Karen Reed did very little, but seemingly had the most knowledge on the state of John O'Keefe, i.e. meaning he's dead. She knew before anyone else.
Upon her driving with Kerry Roberts and Karen Reed to the 34 Fairview Road, the address of the Alberts, and that being a detective with the Boston Police Department there, Brian Albert, and that was where a party was after the attendance at a bar, the Waterfall Bar, in the up till around midnight the evening prior. So this 911 call is very.
What's going on? Is he in the bottom of a submarine? What is this? What is this behind him? What is this weird thing behind him? I know it's supposed to be relaxing to the eyes, but come on.
Very revealing. It's so revealing, I think, that it shows so much of what I've been talking about in terms of constitutional due process and reasonable doubt. And this is right, really crystallizes and drives home the point that for reasonable doubt, all you need is one reasonable doubt. If you can only come up with one
it's not any doubt, it's reasonable doubt. How does that put reasonable doubt? He's just going to throw out these words: reasonable doubt, due process, reasonable doubt, due process.
Reasonable doubt as a juror, you must acquit. You must find the defendant not guilty. So that's how our justice system works. You may think somebody's guilty, but if the weight isn't there and you have a reasonable doubt and you're still wondering what really happened, well, that's a reasonable doubt if you don't really know what happened. And then just as we have in this case, the prosecution has no cogent, logical, consistent, straight answers for what happened to John O'Keefe that night.
LOL. You know who doesn't have any straight logical answers? The defense. This is like, are we in opposite world? Are we in opposite world? Karen Reed reversed into him, going 24 miles an hour with her foot 75% on the gas pedal. We know what time. It's going to get even more detailed this time round. She clipped him on the side and he spun out and hit his head on the hard ground. Something else hard. What happened on the defense side? Where's your evidence that something happened on the defense side?
They're parading up.
I mean, this is like absurd compared to. There's much more evidence against Karen Reed than there is Wendy Adelson.
Witness after witness that has credibility full of holes, and they can't make any sense, and they're bobbing and weaving and trying to deflect, and they won't give you a straight answer, and other answers that they give that seem straight just belie anything about that we know about human life and experiences. So
if I just talk in generalities, it'll make it seem like I know what I'm talking about. They're just bobbing and weaving and talking in generalities, exactly what the defense is doing. I haven't read any of the actual moving papers in this case, but I'm just going to talk endlessly, throwing in words like probable doubt, reasonable doubt, due process. Is there anything else I can throw in? How pathetic. How pathetic. I can't even watch any more of that. It's like ridiculous. It's torturous, right? I won't torture you with it. My brother had a brain tumor. This is how he acted before his diagnosis. Not funny, but true. It's odd. His stupidity, right? It's just, he doesn't know what he's talking about, so he can't talk in specifics. He doesn't know the case. I mean, is he really just trying to please his wife? I mean, is this how pathetic it's gotten? I don't think so. I think it's more than that. I think he doesn't care. He doesn't care that he's supporting a killer. He doesn't care as long as he desperately wants power and money. And he thinks this is his ticket. We'll just talk in generalities, and that he knows this is a guaranteed audience for him. Just the way, if you talk about the Adelson case, you're pretty much guaranteed to get some audience. Doesn't mean it's going to be a big audience, but some audience. But with Free Karen Reed, if you talk about Karen Reed being innocent, you'll definitely get an audience. They'll all flock to you. I remember the first time I covered Karen Reed. It was like, they put it up in the Free Karen Reed Facebook group. A lot of Free Karen readers in the audience because they didn't know which way I was going to go. They didn't like I was skeptical. I didn't know at that point. I was just skeptical. So they know what dog bites look like, having been bit by a dog. And that's not it. Oh, they're very late. This is really unusual for Karen Reed. Right. There's so little evidence that it took them 8 weeks to make for the Commonwealth to make their case. Right. Well, justice for Dan Markel is very important to him, but justice for the O'Keefe family, he doesn't give two cahoots. Right. Manny says, I'm convinced. I'm convinced. Nice. Free Karen Reed, right? So stupid. So dumb. The dumbest movement. Most predatory, disturbing movement. All right, I'll be right back, guys. I just have to make a cup of coffee. I'll be right back.
With that, the
So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
It seems the defense characterization that's forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant. and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway? All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank you.
Thank you, Your Honor.
Okay. So Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right.
Okay.
That has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition, Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites 2 specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court denies the request of the Commonwealth to have a voir dire hearing on Lieutenant Wing. At a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Alessi.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
Just a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we've given them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes.
give
We'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So, all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
Well, we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, if he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're their statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right. Defendant's motion for specific discovery, paper 638, Jimmy. All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay. Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Number 5. Yes, With regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses, motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12th, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's arguing this?
I vote aye.
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. The With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
the
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So
Desperately
address
does
number
not
one, please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the
on the biological
I get
side.
there was a difference
Right,
between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counsel Tagbar, please?
This is absurd. This is absurd. They're still acting like they didn't talk to ARCA, like that this wasn't all exposed. All their communications and that they collaborated with ARCA's testimony. They're still acting like that didn't happen and that they can't talk to them and that they just were allowed to talk to them in March. And the judge says nothing. Just lets them lie. It's like the Wild West in Massachusetts. What is going on? Hey, Jude says, Roberta Glass, hardest truther on the interweb. Thank you. You're welcome. So tired of this. It's like, please, Mr. Jackson, please lie to the court and then I'll approve it. Please let me help you sandbag the Commonwealth. I'm so tired of this. And, Maestro made the best point. This is what she said last time. You're going to put up 3 witnesses that you've never talked to? Yes, we are, Your Honor. Well, the report is clear. No, the report isn't clear, says the judge. I'm still unclear with who does what, but go ahead and testify anyway. We'll have this pointless voir dire. And Hank Brennan's like, at this point, I don't care about another voir dire. It's not going to help him. He's like, how is a voir dire going to help? I don't know the questions to ask. This is their technique. They want to sandbag the prosecution. And Alan Jackson just lying and lying and lying. I'm so curious to know what's going on at the sidebar. I hope it's not what I think. The judge backing up the defense. Hope not. She's not over her head. She's a former defense attorney. She knows all this stuff. She's just okay with all this kind of fraud. That's... What's hilarious is that the Free Karen readers think she's biased for the prosecution. It could not be more untrue. I mean, who would let Marie Russell, who would let McNasty Green testify? Any other judge? No one would let them testify. They're literally people who stumbled from the street, down on their luck, tumbling down the the lowest realm of their career, the lowest rung of their career, stumbling into court. Yeah, Karen Reed's the only one. And I love also that they don't want Karen Reed to be on the bus with the jurors. Can we please keep our client as far away from the jurors as possible? She's so unpleasant. Speaking of, let me just quickly go through Hank Brennan's cufflinks. So here they are. Thank you to who did this. They were sold in they're Jan Leslie Winking Owl cufflinks. This is a blue version. They were sold by Jan Leslie at Bergdorf Goodman for around 2009, 2010, I believe. Because I actually had some of that soap on the right, and that's around when I bought it. I think at TJ Maxx or something. So maybe even earlier. But Jan Leslie, now they're about $600 or $700. So that's what we're talking about. Those are his cufflinks. Jan Leslie enamel winking owl cufflinks. We've sussed it out. We've sussed out the mystery with the help. Yeah, they are owls, Debbie, with the help of my audience. They gave me a much better picture of them, and I was able to find what they are. Yeah, it's weird, right? There's different themes that go in and out of different cases, right? The owl. I just think Carl Steinbeck, it's hard to believe he's free Karen Reed. It's kind of not. He'll just go on the popular side of any case. I didn't think he was like that, but apparently he is. He'll support any killer as long as it'll bring him clicks and status and money. Yeah, he would support Donna Adelson if it were popular, or Wendy, or if it were popular, he would. It's just not popular. It just seems like the true crime community wants you to support some killer or another to seem fair and balanced, and that's never been something I've been interested in doing. Could do. You never see me support a guilty killer on this on this channel, no matter how unpopular, or a predator, or a wife beater. You got a copy of Boston? I have a copy of it too. That's the OG innocence fraud book. I haven't I haven't finished it either. I haven't finished it either, Debbie. I didn't recommend it. I was just pointing out that was an innocence fraud book. I was talking about the biography of Upton Sinclair that found out that he had embedded himself in the defense, and the defense attorney was saying that he had gotten Sacco and Vanzetti lawyers. I wasn't recommending it. It's one of the original. I will probably read it at some point, but it is long. You're right, Debbie.
All right, so Mr. Jackson, you're saying that the ACRA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what
do?
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. Okay. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right. Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welsh's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need, or witnesses that we've decided we don't need in this case, and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alessi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025, And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number on what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
What a shameful judge. Shameful. Please, Alan Jackson, please lie to me. I don't have a problem with Alan Jackson being heard. It's just the consumption of his lies. And we're going right into another, you know what? We're going to go right into another hung jury this way. There's a reason we have rules to our legal system to keep things fair. And because the defense cannot win doing things fairly, they cheat to win, and Bev lets them. I never like to call her that. Judge Cannoni lets her. But I'm just disgusted with this. Anyone else disgusted? I mean, all the Commonwealth is asking for is basic fairness. This is what they asked for last time. And Judge Cannoni's like, oh, we'll have a voir dire. What was that voir dire? It didn't help. If you don't know the questions to ask, it's not helpful. Well, we'll punish them with a voir dire. Oh, voir dire. Oh, that's going to be punishing, terribly punishing for the defense. Then we can still ambush the Commonwealth because they can't have their experts dispel anything that they say at the last minute. It's right. It's vile. It's unfair. I know, right? This makes me just want to not watch the trial because I just feel like we're going into disaster. You know, going into disaster. It's so beyond. It's so beyond. Let's take a musical break, shall we? Or we're going into an acquittal. Hung jury would actually be maybe a slightly better outcome. Or we're going into an acquittal based on nonsense, based on conning the court.
I'm a tiny man, bark as bad as my
So what's amazing about this? What happened to our live stream? What's so amazing is that over 100 years ago, in this same courtroom, Sacco and Vanzetti were cause celeb of the 1920s, convicted of murder and executed after a trial many felt was a farce. It wasn't a farce because of the Commonwealth. It was because they had their own turtle boy with a little bit more of a reputation, better reputation, Upton Sinclair. So essentially, my understanding was a communist. He wrote extensively about the case and he embedded himself in the defense. But it wasn't until 2006 when, so he wrote this book, Boston, based on this Sacco and Vanzetti trial, that basically convinced the whole world, it's like an innocence fraud book, that they were innocent and that it was anti-immigration, immigrant feelings that convicted and ultimately executed Sacco and Vanzetti. They killed 2 guards in a robbery. Newly discovered letters in 2006 revealed suspicions that the men were guilty. A California man browsing through boxes at an auction unearthed a fascinating discovery. A dusty letter dated 1929 from famed muckraker Upton Sinclair. Sinclair had just published a novel called Boston about the murder trial of anarchist Nicola Sacco and Bartolomeo Vanzetti. Sacco and Vanzetti were a cause celeb during the 20s. Left-leaning intellectuals, including Upton Sinclair, championed their innocence, whereas we have right-leaning people championing the innocence of Karen Reed. Their eventual execution in 1927 touched off riots in Paris and London. Upton Sinclair's letters revealed he knew more than he let on about the case. So they interview the biographer who discovered these letters, Anthony Arthur, who says, so in this letter, Sinclair describes meeting with Fred Moore, who were Sacco and Vanzetti's lawyers at the time. They're meeting at a hotel in Denver. And he writes, quote unquote, alone in a hotel with Fred. That's Fred Moore, the defense attorney for Sacco and Vanzetti. I begged him to tell me the full truth. This is Upton Sinclair, the author, who's writing, who embedded himself with the defense team. He told me that the men were guilty, and he told me in every detail how he framed a set of alibis for them. But he goes on to say that he found it the most difficult ethical problem of his life, but that he felt that he had to write a novel of innocence because that's what the public expected. The biographer, Anthony Arthur, says that Boston is a fair representation of the evidence on all sides of the case. Even if the men were guilty, he felt the larger context of the world in which they were living rendered their guilt perhaps less important than it might have been otherwise. Meaning, so same thing here with Karen Reed. If you don't like the police, you feel like the police need to be exposed, it's more important that Karen Reed gets off. Same kind of thing. You want me to go back and watch the... Okay, hold on.
Read them continuously through the trial. Mr. Greeno is responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse different pieces of my discovery request, but we do not have all the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr. Jackson.
The number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March.
Clearly, they didn't have to give you permission because you did talk to them. All the communications are out, Alan Jackson.
26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that if the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the biological side.
There was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
All right, I'm keeping my eye on.
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. That is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counsel Tagbar, please?
Sorry, I thought they went to sidebar a little sooner than they did. I'm keeping an eye on the fan. Another tab.
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
that is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what
do?
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that. All right. I probably have it here too. I have one, Jim. Thanks. All right. I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradle.
All right. Thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you
I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Well, that was dramatic. So this is something he's been threatening on social media to do. Take his Fifth Amendment. He's going to plead the fifth. The fifth. You've seen the Chappelle show? I hate lawyers. I'm sorry to hate them too, Eileen. It really goes against, all goodness and all humanness and all rationality. These legal arguments, don't they? Don't they? It's scary what these sleazy lawyers can do. And I was watching People versus Whitey Bulger, or USA versus Whitey Bulger. And I don't know what went on in that case. I don't know who to believe, but I'm inclined not to believe Hank Brennan. But he says Whitey Bulger wasn't an informant. It may have been some kind of looser agreement. I don't know. But the maker of that film is one of the duo that made the Paradise Lost 3 movies about the West Memphis 3, where they left most of the evidence against the West Memphis 3 on the cutting room floor. So I don't know what to believe. But what a scary client, Whitey Bulger. Yeah, so I guess he's going to come back after lunch and plead the fifth. All right. I'll see you guys after lunch then. All right, Debbie, I'll be back in 10 minutes then. Oh, here's something curious that Jennifer Harmon sent me. Here's Victoria George acting as a lawyer for Karen Reed, not invited into the sidebar, but she's passing notes to someone in the gallery. What's that about?
is it true you were a crack cocaine dealer for 7 years?
I plead the fifth.
Sir, will you tell us about the cartels you dealt with in your time as a crack cocaine dealer?
No, but I can tell you that I plead the fifth.
Exactly how much money did you earn in your time as a crack cocaine dealer?
I said there are so many amendments in the Constitution of the United States of America. I can only choose one. I can only choose one. I plead the fifth. I plead the fifth. 5, 1, 2, 3, 4, 5. Anything you say, fifth. Go ahead, ask me a question. Did you? Fifth. I have a secret document that I think you need to say.
That'll be all, sir. Good afternoon.
I got your sentence reduced to a month, buddy.
You are unmuted.
Court is back in session. You may be seated.
All right, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to consider his Fifth.
I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
Notice how no one on Karen Reed's team gets up like, oh, it doesn't have anything to do with us. Give me a break. I thought it was 19 or 20 now, but apparently it's still only at 16. Yeah, it's only 16, Kitty. You're shocked too?
Tori, Jim.
Yes.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something that we've done.
Right. Understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants brief, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so the court, please.
Okay, that's it. So this starts Tuesday. Unreal. Unreal. What the defense has got away with in this case. And to have Aiden Carney in the courtroom. It's too much. I feel like I'm watching a moving wreck. That's what I feel like I'm watching. All right, I'll see you guys all at 6. Have a good one.
I hit my boyfriend with my car. It wasn't an accident. But with lying lawyers, I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin, making money. Truth is my second victim. Carry, Jen. Like John, you were my mark. My innocence fraud campaign is my biggest hit yet. Yeah. I hit my boyfriend with my car. It wasn't an accident. But with lying lawyers, I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin, making money. Truth is my second victim. Carry, Jen. Like John, you were my mark. My innocence fraud campaign is my biggest hit, yeah.